Hello, my name is Rebecca Ferguson and I'm Head of the Department of Negligence Law in the Queensland Law Society. Thank you for joining me today. I greatly appreciate all of you taking the time out of your very busy schedules to attend this seminar. This presentation to the Queensland Corrective Services Executive Board will delve into the roles and responsibilities that prison authorities hold in regard to negligence law in Queensland. It's been chosen to present this presentation to the Board of QCS so information can be shared appropriately with necessary departments. The Queensland Corrective Services transparency in fulfilling its duty of care for prisoners has raised concerns. Transparency is vital in the correction system, encompassing access to information, conditions of confinement, use of force, accountability, and access to legal remedies. When transparency is lacking, it can hinder prisoners' understanding of their rights, oversight of conditions, investigations into misconduct, and their ability to seek legal redress. Addressing these transparency issues is crucial to uphold prisoners' rights and maintain effectiveness and legitimacy of the correctional system. As per the recently published annual report on deaths in custody by the Australian Institute of Criminology, it has been revealed that mortality rate among prisoners rose from 0.15 per 100 prisoners in 2020 to 2021 period to 0.21 in the 2021 to 2022 period. This number is alarming, therefore we need to clarify what the law and regulations are surrounding negligence of prison authorities. This presentation will present information that has been gathered from multiple reliable sources in relation to negligence law in Queensland. The discussion of the issue of personal injury liability is imperative as prison authorities have almost complete control over the detainee's environment. This means that in various circumstances, potential carelessness of authorities could harm those detained. We will first work through the current state of negligence law, legislative materials, and common law. Each different body of law will be discussed thoroughly, so we will be able to effectively determine what the current state of liability of prison authorities is in negligence law. Following this, recommendations for further reforms will be made with the aim to spread awareness to this topic of negligence law. The prison environment poses various risks to inmates, and when prisoners are injured, they may have grounds to sue the prison authority for negligence. Such claims are typically evaluated based on the standard negligence principles, with some consideration for public authorities. Despite involving generic legal tests, prison injury cases have recurring features and argument patterns related to breach of duty. Undoubtedly, police officers bear a responsibility to act with a duty of care to prisoners. However, the conversion of this duty into a private duty within the evolving framework of negligence tort law remains a subject of great debate. The initial step in the transitioning this public duty into a private one in negligence lies in the establishing that the defendant owes a duty of care to the plaintiff. Without such owed duty, harm resulting from the defendant's negligence actions cannot be remedied. Reasonable foreseeability, as mentioned in the case found on the slideshow, consists of assessing whether harm or risk resulting from the defendant's actions was reasonably foreseeable. One crucial factor in determining whether a duty of care exists is the concept of reasonable foreseeability. Courts assess whether at the time of the defendant's actions or omissions, a reasonable person in the defendant's position would have foreseen that their conduct would result in harm of plaintiffs or others. Control tests as established in Caltex Refineries, Queensland Proprietary Limited and Stavar 2009, where the extent of the defendant's influence or control over the situation is to be explored, which can affect the duty's scope. Control tests in the context of a prisoner versus police guard situation assess the guard's capacity to prevent harm to the prisoner by examining their authority and influence within their role. Police guards in custodial settings typically have significant authority and responsibility, also maintaining order and safety. These tests also consider the directness of the relationship between the guard's actions and the potential harm to the prisoner. The level of control and authority implies a duty to take responsible precautions to prevent harm, such as preventing violence and ensuring access to medical care. Ethical obligations reinforce the need for guards to prioritize prisoner safety. In Sullivan and Moody 2001 and Miller 2011, policy considerations played a crucial role in understanding the distinction between legal policy and public policy. as well as in assessing the imposition of a legal duty. These cases provide insight into how the broader societal and legal context can influence the application of such duties. In legal context, legal policy pertains to the principles and guidelines established by the judiciary to shape the development and interpretation of the law, ensuring consistency and predictability. Conversely, public policy encompasses the broader societal concerns and values, reflecting on what society deems just, fair, and reasonable. In both cases listed, there was no explicit requirement for the courts to assess the fairness, justice, and reasonableness of imposing the duty. The absence may indicate the potential tension between strictly applying legal principles and considering public policy concerns. The broader societal context could have included changing attitudes towards duty and liability, influenced by evolving norms and perceptions of the risk of responsibility. The legal context may have involved existing case law and statutes that set precedents for duty imposition. Policy influences, whether legal or public, can impact the context and application of duty. Legal policies seek to uphold established legal principles and ensure consistency, while public policy may advocate for adaptability in response to evolving societal values and expectations. In summary, Sullivan and Moody and Miller exemplify the interplay between legal policy and public policy in negligence cases. Although these cases did not explicitly require an assessment of fairness, justice, and reasonableness, they emphasize the challenge of balancing legal principles with societal and policy considerations in determining the extent and application of legal duties. Both legal and public policy influences should be considered in shaping negligence law. Contemporary negligence law is guided by the neighbourhood principle as found in Donoghue and Stevenson, 1932. It suggests prisoners meet the criteria for a duty of care due to their vulnerability. Imposing a strict duty on prison authorities could result in a surge of challenging and costly claims. Found in New South Wales and Bujuduso, 2005, a common law approach to the liability of prison authorities stated that the duty on those responsible for one of Her Majesty's prisoners is to take reasonable care to the safety of those who are within, including the prisoners. Actions will lie. For example, where a prisoner sustains injury as a result of negligence of prison staff or at the hands of another prisoner in consequences of the negligent supervision of prison authorities with greater care and supervision to the extent that it is reasonable and practicable, being required of a prisoner known to be potentially at greater risk than other prisoners, or if negligently put to work in conditions damaging to health, or if inadequately instructed in the use of machinery, or if injured as a result of defective premises. Also found at the level of common law, independently of a duty imposed by the statute, a superintendent of a prison does owe a common law duty to exercise reasonable care for the safety of a detainee while in detention. This was recognised in the High Court in the case of Howard and Jarvis, 1958. This further reflects the duty of care that is owed to prisoners from prison staff. When referring to the Civil Liabilities Act, the CLA leaves duty of care for the most part to the common law. It implies that there is no universal test to establish the presence of a duty of care. The contemporary Australian approach for ascertaining the existence of a pre-established duty of care is found in Section 9 of the Civil Liability Act 2003, which is shown on the screen right now. The information presented in the Act appears to be comprehensive, yet it does not directly address the duty of care that prison authorities owe to prisoners. While the Act may provide some provisions that relate to prison operations, regulations, and various aspects of inmate management, it does not explicitly outline the specific responsibilities and obligations of prison authorities in safeguarding the well-being and safety of incarcerated individuals. Consequently, it is essential to recognize that the Act may cover a wide range of aspects concerning prisons, but the explicit duty of care owed to the prisoners by the authorities is not outlined elsewhere in relevant regulations, policies, or legal precedents. The fundamental elements of negligence are crucial as they provide the framework for assessing and providing negligence in legal cases. Duty of care establishes the legal obligation. Breach of duty indicates negligence, and causation links the defendant's actions to the harm suffered by the plaintiff, collectively forming the basis for liability determinations. Should a plaintiff effectively establish the presence of a duty of care, breach, and causation, they become eligible to receive compensation for the injury or harm they have endured. This ultimate component of a negligence claim is commonly referred to as damages. The issue here revolves around the reliance on the common law principles such as negligence. Common law developed through judicial decisions over time forms the foundations of numerous legal standards worldwide. However, this reliance presents various complexities and draws backs in the legal system. One key concern is the inconsistency common law introduces, leading to varying interpretations and its outcomes resulting in legal uncertainty. Additionally, its intricacies can hinder access to justice for those without legal backgrounds, while the absence of legislative guidance possesses challenges for legal professionals. This reliance can also lead gaps in addressing emerging legal issues and lead to insufficient resource-draining legal processes. Legislative recognition and codification of these principles are vital to provide a more structured and accessible legal framework addressing these challenges. To address the issue of promoting values and demonstrating commitment to the duty of care for prisoners, the Queensland Corrective Services should consider the following reforms. First, enhance transparency by clearly outlining QCS's values and commitment to prisoner well-being on their official website, making this information easily accessible to the public. Secondly, provide regular updates on policies, procedures, and statistics related to the prisoner welfare to build trust and confidence within the local community. Thirdly, ensure QCS staff receive proper training and education on the values to translate them into practice. Additionally, engage with the community, including NGOs and legal experts, to gather feedback for improvement. Consider establishing independent oversight mechanisms to review and evaluate the duty of care implementation. People in prison face substantial and enduring health challenges, including mental health issues, chronic diseases, communicable diseases, acquired brain injuries, tobacco and alcohol use, and recent drug use at higher rates than the general population. Enhancing the health and well-being of incarcerated individuals, as well as sustaining these improvements post-release, has positive effects on the broader community. Given the array of health issues faced by people in prison, it is evident that a duty of care should be extended to protect them from harm. This duty encompasses ensuring their physical and mental well-being, addressing their unique healthcare needs, and striving for their rehabilitation and reintegration into society. Incarcerated individuals possess human rights, although these rights are more constrained compared to those enjoyed by individuals in general population. When a prison places restrictions on these rights that go beyond what is necessary for confinement, it is the duty of prison authorities to protect the incarcerated individuals from further harm. The duty of care to protect individuals in prison from harm primarily falls on prison authorities. It is their responsibility to provide a safe and secure environment to address inmates' health needs and promote their overall well-being. Following all of the information presented regarding the liability of prison authorities, it is concluded that prison authorities have the duty of care to inmates. Due to the hostile environment of prisons, guards should be separating prisoners that may cause harm to each other, making sure that prisoners receive necessary treatment, and also making sure that prisoners do not have access to illicit substances. On behalf of the Queensland Law Society, I thank you for taking the time out of your day to listen to this informative presentation. When we work together, we will be able to achieve a legitimate and just use of power. Thank you very much.